What up, Dope Biz Nation? It's your boy Tay Biz TV, man. We coming at you with a new motion from Marquavius Huey. It's a renewed motion for bond based upon a change in circumstances. Go ahead and like this video. Go ahead and share this real quick, man. This is absolutely something that just happened today, about an hour or so ago, but a few hours ago. So go ahead. Let's go ahead and get into this real quick. So it says here that the state of Georgia versus Mr. Huey. It's a renewed motion for bond based upon a change in circumstances. It says here comes now Mr. Huey, a defendant in the above style case, and files his motion for mistrial and or renewed motion for bond based upon change in circumstances, and respectfully request this honorable court consider the following facts. Here are the facts. Background: Mr. Huey was booked on Fulton County Jail December 14th, 2021. He remained there uninterrupted in uninterrupted custody without bond since that date of the arrest of his grand jury bench warrant. Mr. Huey petitioned this court for bond on September 8th, 2022, wherein the court denied the case. They denied the motion for the bond, despite proffering substantial information to the court to meet all of the Ayala factors for bond. OCGA section 17-6-1 provides as follows. A court shall be authorized to release a person on bail if the court finds that the person, number one, poses no significant risk of fleeing from jurisdiction of the court or failing to appear in court, poses no significant threat or danger to any person, to anyone in the community, to any property in the community, poses no significant risk of committing any felony pending trial, and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. Jury selection in this case began on January 4th, 2023, over a year ago. Jesus, man. A petit jury was seated on November 1st, 2023, and opening statements began on the 27th day of November of that same year. And on April the 8th, 2024, the trial court issued an administrative order regarding the length of trial and noted that as of the date of that order, only 56 of 210 witnesses had testified by that point in the trial. This case, the fact that it was 210 witnesses is mad crazy. This case has been labeled as the longest case, the longest trial in Georgia history. These are the change in circumstances. Let's go. When a court has previously heard a motion for bond, its ruling is not subject to change unless the court finds that the movant has presented new information, testimony, or evidence that indicates a change in circumstances. Winbush versus State. On June 7th, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, his attorney indicated in open court that Mr. Copeland did not wish to testify. Remember, he said he pleaded fifth. She fired and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and went over with him how the immunity, which the state granted to Mr. Copeland, would impact his requirement to testify in court. That's that forced immunity. Judge Glanville also explained to Mr. Copeland that the state would further request that he, Mr. Copeland, Lil Woody, be held in contempt of court if he refused to testify. Remember that day? That's June 10th. Mr. Copeland was ultimately held in contempt and jailed after he pled the fifth in open court before the jury. That was on June the 7th. That was on June the 7th, 2024. Let's go down here. And it says here on June 10th at approximately 9:10 a.m., Judge Schlimeville met with counsel for the state and stand-in counsel for Mr. Copeland. The meeting took place in Judge Glanville's chambers. Counsel for defendant, Marquavius Huey, nor any other counsel for any other defendants, nor any other defendants of the trial participated in the meeting, and were not aware that the meeting even took place. The prosecutor told Judge Glanville that the purpose of the ex parte meeting was to impress upon Mr. Copeland. That sounds like coercion. To impress upon Mr. Copeland the risk of refusing to testify. Yeah, like all that jail time he was going to get when after all of the trial was done, which would have been way past the 2 years, and allow Mr. Copeland to ask questions before he testified. The prosecutor also spoke with Judge Glanville about concerns she had about Mr. Copeland's representation. During the ex parte meeting, the state prosecutors told Lil Woody that he could remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 current on trial. Remember, there are other defendants that's been severed from the trial, and he's talking about all of them. After the ex parte meeting and immediately before Mr. Copeland was brought out to testify, co-defendant Williams' lawyer advised the court that he was aware of the in-chambers meeting that morning and objected to it. Mr. Williams' lawyer, that's Brian Steele, YSL Steele, was held in criminal contempt for his refusal to tell Judge Glanville how he came about with the information. Mr. Williams' lawyer and all defendants' counsel moved the court for mistrial, which was denied. The defendants' attorneys also requested a copy of the transcript from the ex parte meeting, which also was denied. The trial of the case continued, Lil Woody continued testimony before the petite jury over objection. Here's another case here, Scudder versus State. Remember, Steele talked about Scudder versus State when he filed the motion for mistrial, when he came across the information. Says the court determined that a criminal defendant has the right to be present and to see and to hear all critical parts of his trial. Remember, this trial was in a critical stage because this whole thing was about Lil Woody. This is a fundamental right and a foundational aspect of due process of law. The court goes on to say that if the defendant waives it in court, if counsel waives it at the defendant's express direction, if counsel waives it in open court while the defendant is present, or if counsel waives it and defendant subsequently acquiesces in the waiver, the right can be relinquished. The Scudder case involved an ex parte meeting by the judge and a witness with a court reporter. The court determined that because the defense attorney sat back and did nothing, the defendant's fundamental rights were removed or waived. In our case, all defense counsel objected immediately to the ex parte meeting, which they did. Non-notice meeting between the judge, state prosecutors, the sworn witness, court reporters, and others. The defendants, therefore, were entitled to be present and to see and hear this meeting take place, and they were not there. As a direct result of this conduct, recusal motions were filed, and the jury has been away from this case for several weeks. You know they've been watching YouTube. And they heard continued testimony from witness Copeland, Lil Woody, that they should not have. All of this conduct shall be considered new information, new evidence, and a change in circumstances requiring that Mr. Huey and other defendants be granted a bond. Mr. Huey and other defendants have spent multiple days in custody during this delayed trial, based upon the actions of the court and the prosecutors, and no fault of their own. They did not delay anything. The state did, not the defendants. Wherefore, Mr. Huey requests that this court grant a reasonable bond based upon a change of circumstances brought by new evidence, new information and considerable delay in his trial brought on by the state and Judge Glanville on this day, July 18th, 2024, by the attorney for defendant, Carlton Matthews. This is a new motion. Do you all think that this bond should be granted? Should there be a mistrial? Should there be a case dismissal? Should there be a bond? Or should there be a continuation in the trial? Y'all let me know in the comments what y'all think. I'm so curious about this. Go ahead and like the video. Go ahead and share the video. Hey, yo, this your boy Tay Biz TV. Thank you all, Biz Nation, for being great subscribers and great viewers of this channel. And I'll see y'all in the comments. Much love.